Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Welcome to this episode of Resolution. Today, we're discussing sports arbitration, from career trajectories and war stories from practitioners in the field to the nuts and bolts of what it is, how it's administered, with a recent case example. My name is Rekha Rangachari. I am the Executive Director of the New York International Arbitration Center and serve as one of the interlocutors for this series. It's my pleasure to introduce our three guests in alpha order by last name. Jeffrey Benz. Jeff Benz is a mediator and arbitrator with JAMS Arbitration and Mediation Services, and also serves as a court-appointed neutral special master. He is dual qualified in the US and England and Wales, and splits time between London and Los Angeles. Jeff's ADR practice covers various industries, including business, commercial, employment, entertainment and sports, healthcare, IP, maritime, personal injury, and real property. Jill Pilgrim. Jill Pilgrim is managing attorney with Pilgrim and Associates Arbitration, Law, and Mediation, LLC, based in New York City. Her diverse career experience includes decades working in the legal, sports, business, and corporate environments in a variety of legal and business capacities. Jill is the chair of the dispute resolution section of the New York State Bar Association, in addition to other leadership roles. And last but not least, Dr. Katherine Simpson. Katherine is an independent arbitrator, educator, and legal consultant with a broad dispute resolution practice, serving on matters administered by institutions including the AAA ICDR, FMCS, CAFA, and ICAC. Katherine was recently recognized by CPR for her outstanding contributions to diversity in ADR. She and her colleagues are also recognized as having broke the story that the presiding arbitrator in the CAS arbitration involving Romania and American gymnasts had a conflict of interest. More on that later, including what the CAS is. So let's get into it. Welcome. Jeff, if you just say hello, please.
Hi there.
And Jill.
Hello.
And Katherine.
Hi, everyone.
And there we are compiled. You've heard their voices for the first time. And so I'm going to ask them first, if you can tell us about your background and how you became interested in sports and international arbitration. And we'll go in the same order of introduction from Jeff to Jill to Katherine. Jeff, the floor is yours.
Thank you. I used to be an internationally ranked athlete in a sport no one could guess without having to use the internet to look it up, but I used to be a figure skater in my youth. And when I started practicing law, there wasn't much of a sports practice that existed out there that had been written down in any way. And I took an interest in doing that in addition to whatever anybody would pay me to do. One thing led to another. I was at Couder Brothers and in part involved in some of its international arbitration practice, which was much vaunted at the time in the 90s. And I ended up as general counsel of the U.S. Olympic Committee for a period of about 6 years and went on and did a variety of other things in sports. I ran into my letter first appointing me to the Court of Arbitration for Sport in 1999, recently while I was moving offices. So I've been involved as a CAS arbitrator since that time. I've served on myriad number of cases across a wide spectrum of issues that the Court of Arbitration for Sport is involved in arbitration as well as in mediation. And I do a number of other things as well outside of that.
Jeff, thanks so much. And it's great to hear how you got into the sports arbitration world, which I'm hopeful both Jill and Katherine will also highlight. Jill, the floor is now yours.
Yes, like Jeff, I was an athlete. Unlike Jeff, I was not internationally ranked. So kudos for him for his success as an athlete. I was on a very elite track and field team that had a number of fellow athletes who were Olympians, future Olympians, now past Olympians. And so I came to sports law and sports arbitration naturally. As soon as I got my law degree from Columbia Law School, my peers in track and field started asking me for help. I started practicing law and in an era where athletes had little or no rights, or at least felt that they had little or no rights. They had never really organized themselves to exercise those rights. When my friends in the sport started asking me to represent them, I said, no, I can't do that because there's this common notion that you graduate from law school and you know how to be a lawyer and practice law, which is not the case. I was a tax attorney at a major New York law firm, and my major New York law firm wasn't in the least interested in taking on pro bono Olympic athletes who weren't supposed to be making any money. That was the heyday of amateur, and the athletes were not supposed to be paid. And I volunteered as a representative of athletes in the national governing body for track and field. And so I did a lot of pro bono representation of Olympic athletes while I was practicing law, first as a tax attorney and then as a corporate attorney. Eventually, USA Track and Field, as it's called now, started a drug testing program which had adjacent to it adjudication of positive drug tests. I was recruited, as were many members of the national governing body, to be an arbitrator on the doping hearing panels, eventually on the doping appeals panel. And I also sat for disciplinary cases. I eventually was also appointed by the USOPC to one of their hearing panels for doping. I'll end by saying that even though I'll say that right now I practice on both sides of arbitration and sports arbitration, I sometimes represent coaches, athletes in filing arbitration cases, and sometimes I'm a neutral in a case that involves sports. I'm an arbitrator in a case that involves sports. As regards CAS, the first time that CAS had an ad hoc division at the Olympics was at the 1996 Olympic Games. I went to Atlanta on my own dime. I was a volunteer for the Olympic Games, and I went to the CAS office and I said to Matthew Reeb, how are the athletes who have issues going to know to come to CAS and who's going to represent them? I didn't get a real clear answer about that. My sense was they hadn't thought that part through too much. So I offered myself as someone who was in town and available to represent athletes. I did catch a case. I think I got the case around, it was not an American athlete. I got the case maybe around 5 o'clock. I heard about it in the afternoon. I filed for the athlete around 10. They said that the hearing would be at 11 the next day. And when I showed up for the hearing, the Olympic committee against whom we had filed didn't have an attorney, and I had to go in the office building and find them an attorney and then explain to that attorney Olympic law in 15 minutes. And then we proceeded with the hearing.
That's quite a story and an introduction, of course, of the CAS that Jeff started, the Court of Arbitration for Sport. Before we get into it further, Katherine, please, if you would introduce yourself and tell us a bit more.
Thank you. And in the interest of full disclosure, I am not an athlete. Yes. But I do recall watching Jeff on TV in my youth when he was figure skating. So I can confirm that Jeff was indeed a figure skater and one of my favorites. And perhaps in the future, one of my students will become an athlete. I start coaching girls track and field next week up here in Michigan. I got my start in international arbitration many years ago as what is called in international arbitration a tribunal secretary. It's a position that is very similar to being a judicial law clerk. And that's actually where I got my first experiences in sports arbitration. I assisted several panels organized under the USADA panel, one of the anti-doping panels. And I recently joined the international panel for sport resolutions in the United Kingdom. So I look forward to learning more about this important field and to becoming more active.
Thanks so much to each of you. Athlete or aficionado, that's where we get into this. So let's talk about the arbitration process and perhaps in specifics, why do we need sports arbitration or arbitration at the Olympics? Jill, you covered this a little bit in your introduction, but any other nuances that you'd like to add, I'd invite you to now.
Yes, the major need for this is to protect the rights of athletes, protect the rights of athletes either from the overreaching arbitrary decisions of their national federations or national Olympic committees or coaches, or to protect athletes from misdeeds of fellow athletes. Before the Court of Arbitration for Sports, and in fact, the Amateur Sports Act, the Ted Stevens and Olympic Amateur Sports Act in the United States, athletes didn't really have an avenue to go to arbitration. So the scheme of having a place where an aggrieved athlete can file a complaint is so important. It empowers athletes in an Olympic scheme and a sports scheme that gives them very little power.
Thanks for that. We're now going to get into CAS, which you've heard referenced before. So let me define it. It's the Court of Arbitration for Sport, CAS. It was created in 1984 by the International Olympic Committee and its president to be a specialist body to resolve sports disputes. And CAS has grown dramatically and now handles a variety of sporting disputes. Notably, a large number of the most high-profile sports disputes, CAS has gotten notoriety and fame for that oversight. But let's really get into what does it mean to have an arbitration proceeding at CAS. And so, Jeff, if you can walk us through the typical steps here.
Sure. And just to segue from the last comment, I would say that the US was at the forefront of sports arbitration in the world. So it first appeared in the 1978 Amateur Sports Act as a requirement for resolving disputes in sports, in Olympic sports in the United States. That is the first time historically that you see reference to arbitration as a vehicle. And then the International Olympic Committee, I think, concerned about an upcoming games in Atlanta and the land of American juries and some high-profile cases that had gone on in sport around that time, decided to really put some effort into this and get it going. A CAS arbitration is very much like a typical international commercial proceeding. There are some differences that are unique perhaps to the CAS process, but for the most part, the proceeding is initiated by the filing of either an appeal, if you are appealing a decision of a sports governing body, or by the filing of a demand for arbitration, if you are taking up the original jurisdiction of the CAS and your clause says that is the way to resolve your disputes. For the most part, the panels are either 3 arbitrators or 1, and the panels can decide whether they wish to proceed on the papers alone or whether there is a hearing that's needed. The basic fundamental structure is that each side gets to make a written submission, and at times there are additional submissions that are permitted, and then you go to a hearing either on the briefs as submitted or in person. Over time, external forces have come to have an impact on some of what CAS does. And for example, recently there was a European court pronouncement, recently it was a couple of years ago, that requires CAS now, had required CAS to change its rules to allow for public hearings if athletes request it. Athletes have requested those public hearings a couple of different times since that was put in place. The most notable case involved a Chinese athlete named Sun Yang, where the world got to watch a full CAS proceeding as it happened live over the course of several days in a ballroom in Montreux, because that was the best space that could be found to run that public hearing. You can find the recording of it online, and it's a very useful thing to watch if you want to get a sense of how these cases go. It was a doping appeal. But now the format for public cases has changed a bit, and the requirement is being met by essentially allowing for a recording of the proceeding and then its public broadcast after the proceeding, as opposed to having a crowd of folks in the room during the hearing itself. There have been a few of those. There haven't been very many of those cases. So unlike commercial arbitration, sometimes the proceedings can have a public eye going on while the proceeding is occurring. The other fundamental difference, I think, is the public nature of some of the outcomes. So for policy reasons, for example, most doping case results are published, unless perhaps an athlete is exonerated and they don't wish the case to be made public. But those kinds of cases, disciplinary cases, match fixing and integrity related cases, those are generally made public because you don't want people to engage in that kind of conduct. And it's a requirement often of the rules that the results be made public, while others are not. So in some cases, for example, the largest cast volume is the football cases. A lot of those are employment related cases, and those often don't see the same light of day that the disciplinary cases do. The cast proceedings, when they do come to an end, they are appealable exclusively at the moment to the Swiss Federal Tribunal, although there's some recent activity in Europe that might suggest that may not persist, at least for cases that originate in the European Union. But the Swiss Federal Tribunal is the court of original jurisdiction for appealing cast cases. The cast cases enjoy a fairly large margin of success when confronted by the scrutiny of the Swiss Federal Tribunal. It's a small percentage that are successful on appeal, and the bases for appeal under the Swiss Public International Law Act are the same things that we're all used to seeing as bases in the New York Convention, because the Swiss PILA is the embodiment of the New York Convention within Swiss law, I think, to put it simply. So that's a very basic overview. The cases can take varying amounts of time, and those varying amounts of time can be fairly quick. CAS is equipped to do cases on an emergency basis at the Olympic Games, for example, in the ad hoc division, where the cases can be resolved within a matter of a day or two. And on the other hand, sometimes cases take longer for a variety of reasons, including the parties' positions and the development of their case and the like, and it can take months. I'll leave it at that, and I'm happy to answer any other questions about the process.
Great. Thanks, Jeff. So for our audience, again, this idea of viewing post-proceeding, publication of some CAS awards available, less so the employment cases, and where the Swiss federal jurisdiction, the sort of reviewing court. Another question that comes up often is, who are the arbitrators that are deciding this? And under the CAS, there's a closed arbitrator list. Can you describe this?
Sure. The CAS consists of a pool of arbitrators of about 400 individuals. It's hard to know at any given time exactly what that number is, and only a few people know what that number is at any given moment, but let's call it roughly 400. At the beginning, I think in the early days, in the 1990s and early 2000s, I think you would have seen quite a few arguments from athletes' counsel that this is a very small list of people, that athletes should be able to choose from a wider group of a pool of arbitrators and the like. But it's come to be recognized that the specialty offered by the Court of Arbitration for Sport of having sports specialists sit as arbitrators is important, and having a smaller list is the only way to really help develop that specialty. And it also is reflective of the fact that there aren't as many sports practitioners in law out there as perhaps in some other fields. This has come to be, interestingly, recognized in, I believe it's footnote. I think it changed this past time in the iteration of the IBA guidelines on conflicts of interest in international arbitration, but I think it was footnote 5, the last I looked at it, where it recognizes that certain specialist tribunals, including specifically in sports, might have a smaller list that includes repeat players and people that often see each other in arbitration cases. The pool itself, sitting at 400, is probably misleading as well, because the customer base for the Court of Arbitration for Sport, the disputing parties, control who gets appointed for the most part. The court institution itself picks the chair of the panels that sit on appeals cases, but for original jurisdiction cases or ordinary cases, the two arbitrators that are the wings pick the chair. And that list of 400, in terms of selection by the parties, quickly slims down. So the conventional wisdom is that about a half of the 400 have done a CAS case before, have sat in a CAS case before, and that a much lower percentage have done more than one CAS case. And probably 10% of the list see about 90% of the cases that are out there. It's hard to tell with that sort of rough proximity to numbers how that plays out, because not all the CAS cases get published on the CAS website, but there is a perception that there are people used much more often than other folks who are often trying to find ways to get appointed. I hope that helps.
It does. Thank you. And it's insightful to know that there's this list. And of course, it winnows based on what the party preference is. But at the appeal level, very much an administrative institutional role. So then let's move to advantages and challenges. And so the next question is about thoughtful that the parties and the athletes are unique entities. What makes them so unique in this process and how they participate? What are the nuances there, particular to sports arbitration as against other types of arbitration? We'll go to Jill and then to Jeff.
I didn't say in my introduction, because I didn't want to prolong it, that I've been general counsel of two sports organizations, both sports of which are in the Olympics. So when I was general counsel of USA Track and Field, I was responsible for all the disciplinary, grievance, and doping arbitrations. I was responsible for the administration, for retaining outside counsel to act as prosecutors if it was a doping case after drug tests. I did training for arbitrators who were going to sit on our cases in track and field. And so what makes it unique, of course, is that it's sports. And not only that it's sports, that it's, depending on the sport, it's Olympic sport. So there's a whole Olympic framework of rules and regulations within the Olympic framework, at the top of which is the Olympic Charter, which is like a constitution for all the participants in the Olympic movement. You have national federations and national Olympic committees that have separate sets of rules. So that is what makes it unique. When Jeff talks about the closed arbitrator pool and expertise, I want to push back a little bit on that from the perspective that, yes, a small group of arbitrators at CAS, by the way, the arbitrators have to go through a rigorous selection process to be on CAS. So it's not like you can just apply and you're on. But I've got to tell you, having been general counsel of two organizations in the Olympic movement, one golf, one track and field. I was the general counsel of the Ladies Professional Golf Association as they were getting back into the Olympics. And I was responsible for creating their first drug testing program for their players. I've got to tell you, the rules and regulations of every sport are hugely different. When one says that someone is an expert in Olympic sport or sport, I query that unless you've sat on a lot of track and field has 40-something disciplines, everything from high jump, long jump, distance running, hurdle, steeplechase, pole vault. The rules for each one of those disciplines and how they're scored are totally different generally. Then you've got golf, which is a totally different discipline. I've had calls from athletes in archery and then had to try and understand the terminology and the procedures in archery and the technical. Every sport has technical rules related to the equipment and the execution of the sport, the way the sport is played. Then it has competition and eligibility criteria. Then it has its whole governance scheme. Then it's got its disciplinary grievance, doping scheme. These are complicated, unique situations. So every case that you might sit on, you may have to learn a whole other new body of rules, regulations related to a sport that you've never been exposed to. So that's where I query about the closed list at CAS, in the sense that a few arbitrators at CAS often get picked. We don't have time to go in why that might be, but they're not all experts in every sport, because they could be picked for a case that they in a sport that they've never sat on, so they've never been exposed to the rules of that sport. So what's unique about sports arbitration and international sports arbitration is that you're dealing with athletes, which is a whole different pool. Athletes are not like commercial participants and business executives. It's a whole different ball game. There's a lot of emotion. There's a lot of skill and dedication that these athletes have put in for decades of their life. So if they're fighting for their eligibility to have this one opportunity to participate in a world championships or Olympic Games, that is so important. In business, you can have a remedy that compensates you monetarily. You can never compensate for the lost opportunity to participate in Olympic Games or World Championships. There's no money that can compensate you for that. The people who are involved in the administration of sport, at least during my 50 years of doing this initially, these were all people who were either athletes themselves or longtime officials of sport. So they know the sport, it's ingrained in them. There's a whole different psychology and philosophy of the sports world. If I talk to somebody about a certain aspect of sport who isn't involved in sport, they might say, oh, I didn't know that. One of the things that happens a lot with athletes in sports is the travel. You're traveling constantly. You're staying in hotels. When all the scandals came up about safe sport and sexual assault, I saw one court opinion that talked about, I've been an expert witness in one of those cases here domestically. I saw one court opinion where the judge was saying, of course something is wrong. You have an adult male walking into a hotel room with a young person. If you're exposed to sport, we travel all over the place. We stay in hotels. The athletes are everywhere with the coaches. The coaches are going in and out of the rooms. There is absolutely nothing that would suggest that is inappropriate if you know the world of sports. It's a whole different context.
With that, thanks, Jill. Jeff?
I would push back on Jill a little bit on the specialization issue and the differences sport by sport. First, fortunately, within the Lex Sportiva, there's developed a rule that says that arbitrators don't review field of play decisions. So that's a very unique aspect of the sport arbitration experience. So there's very rarely a case where you're going to get into the substantive rules around various aspects of how you perform the sport, aside from actually making the determination that the decision that is being appealed or challenged is a field of play decision. Why do we have the field of play decision rule? Because we don't want Monday morning quarterbacking in the simplest sense. And sport officials are allowed to be wrong. They can't be intentionally wrong. They can't be wrong because of some countervailing affiliation or involvement, such as corruption, bias of some significance, or some other bad motive. But we have this rule that is unique to sports arbitration that excludes those cases as a matter of common acceptance and law from the jurisdiction of arbitral institutions in sport. The other part of it is that sport, while you organize yourselves in different ways depending on the sport you have, there's a whole lot of patterns. And I've been doing this since I was a child as a figure skater, but there are a whole lot of patterns about figure skating that you can apply to the organization and conduct of sport. You name it. I'm now involved in professional boxing, and there are common elements that travel as between those things. So I think when you talk a little bit about the specialization of sport, you have these kind of decisions that are being made by individuals who are independent and impartial from the parties for the most part, but are knowledgeable about how sport chooses to conduct itself and organize itself. I also think that the ability of a cast panel at the Olympic Games to come from zero to an award within a matter of hours, basically, is fairly unique to sports arbitration. I have yet to find a commercial tribunal that has been able to do that In any case, you would think that you might be able to find that capability if you had a case of spoilage of products on a dock somewhere or some other sort of commercial adventure. But CAS has really perfected this ability to be able to get to a relatively quick decision. And to put it in context, Jill gave you a flavor of some of it for a case she had in the 2002 Olympic Winter Games in Salt Lake City. Apollo Ono, who later went on to Dancing with the Stars, I think, fame. He was judged as the gold medal winner in a short track speed skating distance at those games because a South Korean athlete was judged to have tracked, I believe was the term. It means they cut him off impermissibly at the end. That's the real summary of what the call is. That case was notified to us at the U.S. Olympic Committee, where I was in attendance as general counsel at about 3 p.m. in the afternoon. We had a hearing by 10 p.m. that night. We finished the hearing by about 3 a.m. and sometime the next morning in the relatively single digit hours, maybe 10 at the latest, we had a decision on that case. That case didn't actually have to go that far except to bring certainty to the medal outcome, but there wasn't like anybody else down the rounds of eliminating rounds or anything like that whose outcome was going to depend on that case. But that's pretty fast as arbitrations go. And lawyers that practice in that environment have to get used to being able to practice through uncertainty and a lot of gray as they go through it because they don't have a lot of time to put their client's case together. So those are the unique elements I see of it.
Thank you each for your perspectives on that. We're getting into our case example, and we're going to call upon Katherine in a moment. I wanted to underscore, as Jeff raised, independence and impartiality are anchors to arbitration generally and sports arbitration specifically. But in either example, it's not devoid of issues arising in the seesaw of disclosures and conflicts of interest. So with that preview, and most recently, CAS came into general consumption during the Women's Olympics gymnastics floor competition. And so, Katherine, to you, can you give us a general overview for our case example?
Yes, and thank you. And before I start, I would like to stress that I do not have any special information. Everything that I know about this case is available in the public domain, and I have not represented any party in this matter, nor do I intend to. I think maybe most of us, I know at least I was, we were watching TV when this started. Everybody was looking on as Jordan Chiles finished her routine. She was the last person to perform, and the camera kept panning over between the Romanian team and the American team. And at one point, the Romanian gymnasts wrapped themselves in their flag and they began celebrating on the floor. There were tears. Everyone was very excited. And then suddenly, those joy tears turned to shock and sorrow when Jordan Chiles's score was elevated to, I think it was 13,766. And that move was just enough to place Chiles in the bronze medal position and to remove the Romanian team. The following morning, the arbitrations began with the first Romanian athlete, Ana Barboscu, alleging that Chiles's score was too high and that her score needed to be revisited. I think that might come under what Jeff was describing as a field of play decision. A second Romanian gymnast filed her claim, alleging that she should not have been docked 1/10 of a point, which she was penalized for having stepped out of bounds. And she argued that the video footage clearly showed that she did not step out of bounds. And those were fairly mundane, but those were the issues that this arbitration started out with. Getting into the issues arising out of the actual arbitration, it's actually really unclear how it came to be that the arbitrators decided out of those two issues that Jordan Chiles's inquiry into whether the judges had correctly or had actually taken into consideration all of her jumps. It's unclear how the issue of whether Jordan Chiles's inquiry was timely actually made it into the dispute. And maybe that's where it starts to get weird. What for me really stood out as soon as this decision was announced was the arbitrators. When the CAS announced their decision, it was a press release and a one-page summary award where for the first time the CAS listed the arbitrators. And the presiding arbitrator, Hamid Garavi, it was interesting to me anyway that he even got to be in the same room as this arbitration, this one in particular, because he has been representing Romania as Romania's lawyer on the international stage for approximately 8 years. And this was why my colleagues and I started looking into this point, because we understand that arbitration by and large depends on consent. But there are narrow spaces where the parties do not even have the ability to consent to something. And one of those narrow areas is where an arbitrator has a conflict of interest that is on the non-waivable red list in the International Bar Association guidelines, the IBA guidelines. And those really come down to this idea, this overarching principle that an arbitrator, or really that any person, no person can be the judge over his or her own case. And the guideline is that an arbitrator who currently or regularly advises a party or an affiliate of a party is not able to be an arbitrator in that case. There is no amount of consent that is going to make that right. And so looking at this case on the facts of it, it's a fairly mundane case, but on the procedure that led up to the decision, it appears to be a decision and a process that led to that decision that could only have been possible if somebody with a grave conflict of interest were to have been at the helm. And here, that's what we have. Somebody with a non-waivable conflict of interest leading the procedure in such a way that really none of the immediate parties before the case actually won. Now, objectively, following this case, both of the Romanian gymnasts had tied scores. They were each tied at 13-7, and it was ordered that Jordan Chiles's original score of 13.66 be reinstated. One could argue that the Romanian gymnasts won. To get there, you have to overlook the fact that the one who actually is getting the medal, Ana Barboscu, she has a bronze medal that very few people actually trust. The second Romanian gymnast, Sabrina Manică-Voinea, if her case had been permitted to go forward, she could have been independently all alone the bronze medalist with a score of 13.8. When I look at this case, I see a case that there was one distinct winning entity, and that was Romania, the presiding arbitrator's client. Romania won this case because Romania exited the arbitration with two gymnasts with tied scores of 13-7, who Romania could validly equally celebrate as bronze medalists. And that is exactly what Romania did. There were parades in their honor. Both women were honored and celebrated equally at home in terms of prize money and in terms of cars. But one has to really wonder, would that result have been possible if Romania's lawyer had not been sitting at the head of this arbitration? And in my articles, I try to go back through different procedural points in this very fast, I think it was like a 72-hour arbitration, maybe 84, give or take, where there were certain procedural moves that led to this ultimate conclusion that Romania could exit this process with two gymnasts arguably tied for third place. So I think I've gone around your question a little bit, and I'm sorry for that.
You've given us a comprehensive overview for those that weren't paying attention to this case from the Women's Olympics. So thank you, Katherine. I wanted to, because there was a lot of conversation about this on the international stage, to give Jill and to give Jeff, if they wanted to, a moment to make interventions in brief before we go to the end. So Jill, please, if you'd like, and then Jeff.
First, I want to say I always enjoy an opportunity to debate with Jeff, and he is very experienced as a cast arbitrator. And I will say that I don't distrust most cast arbitrators, but to give you an example of, yes, it is true that field of play decisions are excluded from arbitration, sports arbitration. One has to determine what is field of play. And in order to do that, you have to understand the nuances and the technicalities of different sports. So in gymnastics, it's very clear, or at least many people would believe, that every time a routine starts, you're in competition, or when the clock ticks that you're supposed to start. In track and field, we have a lot of different events, right? A sprint starts and stops, and then a high jump is going on. There are all these different disciplines. In golf, is it when you tee off, the first player tees off? Is that the beginning of competition? And does it stop when you start walking to the next tee? In specific to this particular case and a determination of field of play, some of the facts that you need to know about gymnastics is that only a player, an athlete, a gymnast can only challenge their own score. They cannot challenge someone else's score. Key to this case was the fact that there's a time limit during which one can challenge. And if you make the challenge too late, then it doesn't matter. Every sport pretty much has that. In track and field, we have a protest period. If your protest is 1 second late, you lose it. It's the same concept in gymnastics. So that's where I agree with Jeff that there are some common principles of sport, but you have to understand the rules and the technical rules of a sport to understand what is technical and what is actually competition. And key, Katherine, to an analysis of this case, and I was waiting for you to mention it, you did mention the IBA rule, but you didn't mention the fact that the parties, the arbitrators, were disclosed to the parties. Their backgrounds were disclosed to the parties. The fact that one arbitrator did business for the Romanian government was disclosed to the parties. And there were several opportunities for the parties to object to the seating of that arbitrator. CAS has a pool of ad hoc arbitrators at the Olympic Games. So if that arbitrator had been challenged, then someone else would have been selected, presumably with no apparent conflict of interest. So I'm going to leave it at that, because I know Jeff certainly will have pertinent comments to make. But there's a lot more to this case. And key to this case is a determination of whether the protest was within a minute. The stepping out of the bounds, it appears that athlete's coach or athlete didn't make the protest. So if you don't make the protest, you lose it. So there are all these things that are happening, but they're within the bounds of the rules. So you can't just apply general arbitration principles to sports. And that's what the outcry tinged with a lot of nationalism. I presented to a group of international lawyers students at Columbia Law School, and asked them whether they thought that Jordan Chiles should have been successful. There was not one student in that room who thought that Jordan Chiles should be successful. And mind you, there were no Americans in the room. So I think there's a lot going on there.
I think it would be only appropriate if Katherine got a reply on this, and then we'll go to Jeff and close. So Katherine, please.
Thank you. And one of the issues in the case is when the U.S. side ever learned about the conflict of interest, because the award itself states at paragraph 15 that everything was disclosed and nobody objected. But if you fast forward over to paragraph 33, which occurred 2 to 3 days later, that was when the arbitrators state that they first realized that no one on the US side had been contacted. There's a time travel issue within the award. And when you go through the filings that the US side has made public before the Swiss Federal Tribunal, they argue that the first time they ever learned of the conflict of interest was in the New York Times reporting of it on August 13th, which was after the decision itself had been announced. They've also provided evidence that every time the CAS attempted to email them and to notify them of the case or of the conflicts, that they received a bounce back message that they did not even take any action with respect to until 22 hours before the hearing. And so there really is an issue here, both of whether the parties were ever informed of the conflict of interest, and secondly, even if they were, whether that was a conflict that could have been waived. Following this award, the CAS has also taken to the news, and in the New York Times and in Global Arbitration Review, has announced that they view their cases and their arbitrators as being bound by the IBA guidelines, which would suggest that non-waivable conflicts of interest do in fact exist. But this is one important issue that is currently before the Swiss Federal Tribunal, and I'm looking forward to seeing how they come out both on the factual issue of whether all of the parties were timely informed and had the opportunity to consent, and also on the arbitration issue on whether consent would have mattered.
The story is not finished. Stay tuned, but let's let Jeff opine here if he wants to make any interventions, and we'll go to close. Jeff?
So I wouldn't add a whole lot. I think that the Swiss Federal Tribunal decision is imminent. I don't know how imminent or what imminency means, but it's been pending in front of it for a while, and I think we'll get answers to some of the questions from the SFT. The SFT has shown in the past a willingness to step into questions about the IBA guidelines and about arguments concerning impartiality and independence. So let's see if they take that invitation here and what they do with it. As a point of post-case reduction, I think the arbitrator in question has resigned from the Court of Arbitration for Sport. I think on his website or somewhere else, he said he did so in part so that he could represent parties before the Court of Arbitration for Sport. So at the end of the day, the Swiss Federal Tribunal decision, while it might affect the proceedings of the CAS, won't have very much effect on any particular individual involved. Let's see how it goes.
Thank you so much. With that, we go to close with still more to come. And so stay tuned again with that Swiss Federal Tribunal and the decision there. But I want to end in thanking our speakers who are all esteemed colleagues and professionals in the space that have enlightened us on sports arbitration and the costs. My hearty thanks to Jeff, to Jill, and to Katherine. And all of their profiles are publicly available and will be hyperlinked in. So do feel free to look further into them and reach out should you have more burning questions from this podcast or otherwise. With that, thanks so much for tuning in, and we'll speak again soon. Have a good day.
Thank you for having us.
Thank you for having us.
Thank you for having us.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.